Hello, visionaries. Welcome and welcome back to my channel. My name is Maresa Talbert. I am the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. So, as my subscriber count has steadily increased, I thank you all for continuing to watch the videos and subscribe. And with that, I've been considering integrating live streams to answer your questions in real time and just to connect more directly with my audience. Let me know in the comments if that is something that you'd be interested in. I've been thinking about it. I've been a little bit hesitant because I'm not sure if that's what people want or if anyone would show up. But if y'all let me know in the comments and say that that's something that you'd be interested in, I'll definitely start to create some type of live broadcast that happens on some level of a regular basis. So let me know. Speaking of live broadcasts, I want to talk about some of the legal considerations that come into play when you are broadcasting live on several platforms at the same time. This could be an instance of someone going live on Facebook, Instagram, and YouTube while they are cooking their dinner, or someone streaming themselves playing the guitar on YouTube and Instagram. Whatever the scenario, here are some factors to consider. Number one is content ownership and licensing. You need to confirm that you have the right to broadcast your content on all the platforms that you'll be using. As a content creator, you may have an exclusive content agreement that only allows you to broadcast certain content on a specific platform. And if that's the case, you'd be in breach of your agreement for live streaming on multiple platforms. Crazy, but it happens. All right, number two, be aware of platform-specific intellectual property policies. Each platform has its own IP policies and terms of use. So that means that content that complies with one platform's IP policies may violate another platform's IP policies. For example, Instagram generally allows for the use of copyrighted music, whereas YouTube is much more strict on the use of copyrighted music. Additionally, a platform may impose more rigorous enforcement of DMCA takedowns than another platform. This is just a reminder to be familiar with the IP policies on each platform where you intend to broadcast your content. Number three is geographical licensing restrictions. Different platforms may reach different geographical areas. For example, TikTok is banned in China. But if you're streaming in collaboration with a certain brand, you may have a license agreement that includes a geographical restriction. For example, you may have a license to use the brand in the United States only and not worldwide. So broadcasting content outside of these licensed regions could violate intellectual property laws. And that could either lead to legal issues or the need to purchase additional licenses. All right, moving right along. Number four is DMCA takedowns. Now, I've talked about DMCA takedowns in several videos. The Cliff Notes version is that DMCA stands for the Digital Millennium Copyright Act, which allows copyright holders to take down it's copyrighted content that has been posted online by unauthorized users. So when you broadcast content across multiple platforms, it could increase the risk of IP infringement, which then could lead to a number of DMCA takedowns. As a creator, you must be prepared to individually address each claim on each platform, which is just time consuming and could be a little bit costly. If you need a DMCA takedown notice, we have one in our TLO marketplace. And if you received a DMCA takedown notice, we have the counter notice response also in our TLO marketplace. You can visit our TLO marketplace at talbertlawoffice.com/TLO-marketplace, or you can hit the link in the description box below. All right, last but not least, number five is revenue sharing and monetization. When your content is monetized on multiple platforms, then IP considerations extend into those revenue sharing agreements. And you know, I talk about contracts all the time. If it's not in writing, it does not exist. What you need to know in this context is that different platforms may have varying rules on how revenue is shared from copyrighted content. And you need to make sure that any agreements you enter into are aligned with those rules so that there are no disputes. So these are just some considerations that help to highlight the importance of understanding the IP landscape across multiple social media platforms, and just a few considerations to help you protect your content and avoid legal issues or other types of disputes. Once again, I want to remind you of the TLO marketplace. If you need a contract, if you need an agreement, we have several different agreements. Head over to talbertlawoffice.com talbert.law/TLO-marketplace, or hit the link in the description box below and get your contract template today. Well, that's all I have for this video. I hope that it was helpful. Don't forget to like, comment, subscribe, and share with a friend. And as always, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. And I'll see you in the next video. Bye.